And today's speaker, as you know, is Professor Nahmod from Chicago-Kent. Sheldon Nahmod is a distinguished professor of law and co-director of the Institute for Law and the Humanities at Chicago-Kent College of Law. He is a well-known expert on constitutional law, civil rights, and the law of Section 1983. He has argued civil rights cases in the U.S. Supreme Court and many other federal courts. And we are very glad to have him here today to speak about the case of United States versus Stevens and the constitutionality of pending crush video legislation.
Thank you, Valerie.
Thank you.
Thank you all for being here. I appreciate the opportunity to talk about the Stevens case and also to continue my profession as a constitutional law teacher, because you're going to get a heavy dose of constitutional law here today, for better or worse. I usually teach Socratic, as Valerie knows well, so I feel very confined not asking you questions. And Valerie also knows that I usually bop around the classroom, but here I am confined to sitting and not getting my aerobic workout during my teaching. But we'll take that into account, and I'll still do the best job I can for you all. Really, there are 5 parts of my talk. The first is dealing with congressional power. That's pretty quick. The second will deal with the free exercise clause. The third will deal with the free speech clause, which I'll give you an overview of. The fourth deals with child pornography. You need to know a fair amount about that, as well as obscenity law. And finally, we get into the Stevens case and finish up with the proposed statute that's pending in Congress these days. How far it'll get, I don't know. You may know better than I. So we're going to talk about all of that stuff, but let me start off with the question of power to protect animals. As you know, animals are property and not persons. Despite that, Congress almost certainly has power under the Commerce Clause to protect animals from acts of cruelty, and states can clearly do the same under their police power, and that's because the state has an independent interest in the well-being of animals, even apart from the interest that owners have in their animals. So let's put that to the side. Let's assume that there are ample sources of congressional power. Congress might even be able to spur the states under the spending power to enact certain legislation to protect animals. But there are constitutional constraints focusing primarily or stemming primarily from the free exercise clause and especially the free speech clause. Let me give you a bit of an overview on the free exercise clause. Until the Supreme Court's very dramatic decision in 1990, the Smith case, the general rule was that if a governmental regulation, ordinance, or statute burdened religion, if it burdened religious practice, then it triggered that level of scrutiny that we know as strict scrutiny, putting quite a burden on governments to justify what they had done. The Smith case was a case in which the court confronted a generally applicable criminal statute that prohibited the use of various kinds of drugs, which included a drug that was used by Indians, certain Native Americans, called peyote. They ingested that drug, and it was a very important part of their religious experiences. And the question was whether that the federal statute that was at issue, the state statute that was at issue in the Smith case, was an Oregon statute, could constitutionally be applied to that exercise of religion. And in what can only be called a revisionist decision by the Supreme Court in the Smith case, the court said, we use rational basis review, not strict scrutiny, in these kinds of cases. The court distinguished earlier cases, which means very simply this, that when a generally applicable criminal statute governs behavior, even if that regulation has an adverse effect on religious behavior, religious practices, and nevertheless we use rational basis review, which means that the states and Congress can enact all kinds of legislation as long as it's generally applicable, and this is important now, does not discriminate on the basis of religion. So that, for example, just to show you how this would work, suppose a state prohibited certain slaughtering techniques with respect to animals to be used for food on grounds of cruelty. That kind of statute would be on its face constitutional under the Smith case, because in the absence of proof of religious discrimination, it's a generally applicable statute dealing with criminal behavior, rational basis review. In marked contrast, suppose a statute prohibits the slaughter of animals for ritualistic purposes. That is a Supreme Court decision a few years after Smith called Lakumi Babalu case, where the Supreme Court held that despite what we said in the Smith case about rational basis review for generally applicable statutes regulating conduct, including that which might be religious in nature, where government discriminates against religion, Smith doesn't apply, and that is almost a per se violation of the free exercise clause. I remind you of one of the purposes of the free exercise clause, and that is to protect religion from the state, and this is a good example, this Lakumi Babalu case, of that kind of situation. So, the free exercise clause does create some constraints on prohibitions against animal cruelty, but it's the free speech case or clause that you've come to hear more about. And let me give you a kind of overview of the free speech clause. We've all been to law school, and if we took free speech, we know that that is, I hope we all appreciated that course as one of the great courses anywhere. What a wonderful subject, a privilege to teach it, but in any event, and even to learn it, but in any event, the free speech clause prohibits government from discrimination on the basis of content and viewpoint. I'll say that again. The free speech clause prohibits government from discriminating on the basis of viewpoint and even content or subject matter. What's the reason? You remember some of this from school. One rationale of the free speech clause is the marketplace of ideas. The idea is that there are willing buyers and sellers out there of ideas, and the government should be strictly neutral when it comes to the force, the impact to be given those ideas. People buy and sell those ideas themselves. That's a conventional rationale. The best way for truth to get itself accepted is in the marketplace, right? The marketplace of ideas. The government keeps its hands off, basically, of speech. Another rationale, which some of you may remember from school, is the self-government rationale. Why do we need free speech? We need free speech in order to govern ourselves. That puts political speech at the core of free speech protection, but nevertheless, those are the two dominant rationales of free speech. Again, people decide what speech is valuable and not the government. People decide. Crucial distinction, which is easy to make in most cases, we're talking about speech and not conduct, because government can regulate conduct for the most part without any free speech concerns. There are, it turns out, certain categories of speech, certain kinds of speech that are unprotected by the First Amendment, that are unprotected. Many of them will be familiar to you. We'll talk about obscenity as an unprotected category of speech. Utterly unprotected. It is what I call in First Amendment hell. Okay? It's not protected. It's down below. There's another category called fighting words. You've all heard of those. Yet another category called true threats. When you threaten somebody with physical violence, usually face-to-face, but not necessarily. And then there is another unprotected category of speech called child pornography. Ordinary pornography would be protected by free speech, but child pornography is not. And as we get into obscenity, let me just tell you what the trend has been in the United States Supreme Court for 20, 30, 40, 50 years. With the exception of child pornography, the trend has been to limit categories of unprotected speech. To limit categories of unprotected speech. I'll give you a famous example. New York Times v. Sullivan. Before that decision was handed down, defamation was unprotected by the First Amendment. Now we know it is protected by the First Amendment, subject, the actual malice, knowing, or reckless falsehood thing. Commercial speech used to be unprotected by the First Amendment, and starting in the 70s, it too became entitled to some protection under the First Amendment. Not like political speech. Commercial speech is intermediate level protection under the First Amendment. Incitement to crime used to be unprotected by the First Amendment. Now it is protected, subject to the Brandenburg test, the kind of clear and present danger test. For the most part, incitement to crime is in fact protected by the First Amendment. All right, that's my little overview of both the Free Exercise Clause and the Free Speech Clause. Now let's delve more deeply into obscenity, child pornography, and then, of course, the Stevens case and what that portends for the future. Obscenity, you remember good old Justice Stewart, bless him, years ago said he knows it when he sees it. Remember that? He never lived that down. He was a pretty good justice for the most part. He never lived that one down. Here is the definition from the Supreme Court's decision in the Miller case, the seminal decision of obscenity regulation. And I emphasize to you that pornography, as a general matter, is not unprotected. Put another way, pornography is protected by free speech unless it is obscene. So this is a special category of pornography. Here is a definition of obscenity. The depiction or description of sexual conduct which must be specifically defined. The depiction or description of sexual conduct which must be specifically defined. It's going to turn out that that's important for us in terms of discussing animal cruelty to animals and crush videos. And the rest of this remember the three-part standard, whether to the average person applying contemporary community standards, the work as a whole appeals to the prurient interest. I have lots of fun in my Conval class, in my First Amendment class, asking students what prurient interest is, and basically the best we can come up with is a turn-on with physical consequences, shall we say. The second standard is whether the sexual conduct is depicted or described in a patently offensive way. And the third standard, or third part of this, the third prong, is whether the work as a whole lacks serious literary, artistic, political, or scientific value. Keep in mind that if the speech at issue, a movie, a book, whatever, if the speech does not meet any one of these prongs, it is protected by the First Amendment. It's got to comply with all three in order to be obscene and in order to be unprotected. Here's what the court in Miller says by way of examples. Obscenity is those depictions or descriptions of ultimate sexual acts, normal, perverted, actual, simulated, or descriptions of masturbation, excretory functions, or lewd exhibition of genitals. Now, we don't have time to get into what the rationale behind obscenity is. Probably the best explanation as to why there's an exception under the First Amendment for obscenity is because we've been doing it for decades, if not longer. It's kind of historical explanation, which is what Justice Brennan in the Roth case one of his first cases on the court, which he surely regretted thereafter, one of his first decisions, he said, this is historical, this is traditional. We've regulated obscenity for a long time. There are aspects of decency, there are aspects of morality. My own take on this is that depictions of sexual conduct are prohibitable because they desacralize what is a sacred kind of act. But that's my own take on it. The key here is the depictions of sexual conduct, the descriptions of sexual conduct, the point I emphasized at the outset. Now, what about child pornography? We're laying a foundation for the Stevens case. Remember that we are not talking about conduct here at all. It's clear that having children engage in sexual acts, underage children engage in sexual acts, can be prohibited. It can be made criminal. That is not the issue. That itself has never been the issue in child pornography. The question is, from a free speech perspective, what about depictions of children or a child engaged in a sexual act? And keep in mind, just to tie this to what I said a moment ago about pornography, pornography is protected by the free speech, by free speech. Child pornography is, as it turns out, not, even if it's not obscene. Child pornography is a new class of unprotected speech. Child pornography doesn't necessarily have to be obscene in order for it to be unprotected. So this is that one case that I mentioned earlier in which the court has expanded a category of unprotected expression. Here is why the court said that child pornography, which again is a communication, it's a depiction, it's a description, can be regulated entirely. It's in First Amendment hell, is because of the unique circumstances involving children. First, the state's interest in the well-being of children, both their physical well-being and their psychological well-being, is compelling. Keep that in mind when we talk about animal cruelty in a little bit. Second, child pornography, the market in child pornography is intrinsically related to sexual performances by children in two ways. It creates a permanent record of the children engaged in sexual activity, and it's closely connected to the distribution network for child pornography. Third, child pornography sales and distribution are an important part of the very production of such materials. All part of a kind of seamless web, the court says. And finally, the court says there is a very modest value in such depictions. Some of the justices in the Ferber case, which is where this comes from, in the Ferber case had a little to and fro about depictions of children in medical books and the like. But that's not what the major concern is in this area. So here's where we are. We know a little bit about obscenity. We know that child pornography is, like obscenity, unprotected speech. And now the question is, can Ferber, the child pornography case, and its rationale be extended to communications, descriptions, depictions, movies and the like of animal cruelty? That's the question before us. And here is what the Stevens case involved. This was an opinion by Chief Justice Roberts. The only dissenter was Justice Alito. And this takes us deeply into some of the theory of First Amendment jurisprudence. But let me tell you what the relevant federal statute did here. It's 18 U.S.C. Section 48, which criminalized the commercial creation, sale, or possession of certain depictions of animal cruelty. It applied to visual or auditory depictions in which, quote, living animal is intentionally maimed, mutilated, tortured, wounded, or killed, if that conduct violates federal or state law where the creation, sale, or possession takes place in the state where the sale, creation, or possession takes place. Now let's leave aside possession. We're not talking about possession of this stuff. The court didn't say a word about that in the Stevens case. Supreme Court, as you all know, struck this down 8-1. First, and so it's a fairly lengthy opinion, and I wonder if it's because the Justice Department was on the side of defending this statute, and also because Alito was so disturbed in his dissent with this. It's hard to know because most of us in this area thought that Stevens was a slam dunk. You may not like to hear that, but Stevens was a slam dunk free speech case. It was a very easy case for the court to decide as it did. But let's get to that in just a little bit. First, the argument was made that we ought to expand the class of unprotected speech from child pornography to include depictions of animal cruelty. And the Supreme Court said, no, we are just not going to do this because, among other things, there is simply no tradition of prohibiting such depictions of so-called animal cruelty. And keep in mind that the court is thinking throughout, as we'll see in a little bit, not only about crush videos, but about hunting and fishing and trapping as well. Next, we're not going to create a special category of unprotected speech, but there is, and here we're going to get a little technical, there's no avoiding it, there is a category, a kind of First Amendment jurisprudential approach which is called overbreadth. If a statute prohibits certain kind of speech and conduct, and if that statute is written so broadly that it covers not only certain conduct that we would all agree could be covered constitutionally, but conduct that is, we would all agree is, cannot be covered constitutionally, and if it covers lots and lots of those kinds of protected speech cases, the result is the statute is substantially overbroad. And it is struck down, here's the key, on its face. It's struck down on its face. Now, again, I don't know if when you were all in law school you spent any time at all on overbreadth. I know in my First Amendment classes I spend a class or two on it, but it's an incredible tool. Think about why this is, by the way, why there is this doctrine of substantial overbreadth. Because if you are somebody contemplating engaging in protected activity, in speech, you don't know whether you are going to be prosecuted and convicted because the statute is so overbroad. It may cover you and criminalize your conduct or speech, or it may not. In other words, a substantially overbroad statute, here's a term that you'll all remember from law school, has a chilling effect on the willingness of people to engage in protected activity. And because of that chilling effect, we are not going to make people be so gutsy that they're going to test it. You know, the only way to test it is just to do it. No, we are going to strike down the statute on its face. And that's precisely what the Supreme Court, this is the reason I'm going into this, it's precisely what the Supreme Court did in the Stevens case. It found the statute substantially overbroad because there were too many examples of unconstitutional applications to render the statute valid across the board. So that, for example, the words wounded or killed that I read to you from the statute, those words go beyond depictions of cruelty. wounding or killing is not the same thing as intentionally maiming, mutilating, or torturing, also words in the statute. So in that kind of situation, the statute would questionably be applied. Also, what about hunting and fishing? And what about protection of endangered species? All of these kinds of things may be implicated by depictions of certain activities involving animals. And there's even disagreement, Chief Justice Roberts said, among the states as to what constitutes cruelty to animals. So this is a broadening interpretation of the statute. There was also, sure.
When you refer to hunting and fishing, what about the section of the statute that I believe it's, that is the conduct illegal, but in the state in which it's performed? Is the problem with that is it's not specific? It doesn't say that it's violated like an animal cruelty statute, because hunting and fishing are legal. So you would think that the statute wouldn't apply to hunting and fishing.
Well, that's precisely the argument that Alito made, but it wasn't persuasive to the majority, to Chief Justice Roberts.
Is that because it's not specific that the conduct is legal under an animal cruelty statute? I mean, because I suppose you
there
could
was
say that
a lot of
hunting with an invalid hunting license, and that would be illegal, and therefore it would include hunting.
Well, that's part of it. Yes, I think that's correct. But there was more, because there was an exceptions clause in the statute as well. There was an exception for depictions with, quote, serious religious, political, scientific, educational, journalistic, historical, and artistic value. That was supposed to not be covered by the statute, and the Supreme Court said, well, we have to take the word serious, seriously, that hunting depictions are not always instructional depictions. Hunting depictions are not always instructional. They're just showing how hunters operate and kill animals. So he had a problem with that as well. What he's doing is saying that there are serious questions as to how far this particular statute goes. And the government argued that it would enforce the statute. The feds argued that they would enforce the statute only against depictions of extreme cruelty. And the Supreme Court said we can't take the word of the executive branch when you have an overbroad statute that they are going to interpret it or enforce it narrowly. That's our decision to make. Basically, what the Supreme Court said here was that it could not, in all good conscience, legitimately narrow the scope of the statute to cover examples involving cruelty, such as crush videos. It couldn't do it given the language of the statute. Now, here is something to keep in mind. Very important indeed. I'm going to emphasize this now and later as well. The court did not decide whether a statute limited to crush videos or extreme cruelty would be constitutional. The court did not decide whether a federal statute limited to crush videos or extreme animal cruelty would be constitutional. One of the beauties, strategically, of an overbreadth challenge, if it's successful, is you don't have to discuss the constitutionality of the underlying conduct because the statute is facially invalid. And we're going to return to that point when we get to H.R. 5566, the bill currently pending. But Alito says some of the things that you might have thought. He said the statute is intended to prevent animal cruelty. It is not substantially overbroad. He would have interpreted the sections 48 as not applying to depictions of hunting, which is legal in all 50 states, and it also should not apply to slaughtering of animals for food. And in his view, the statute was susceptible of a narrowing statutory interpretation. Crush videos, so on and so forth, closely linked to the underlying criminal conduct. Ferber applied here. Ferber applied here. The analysis applied, he admitted that the government interest in the well-being of animals doesn't rise to the level of the government interest in the well-being of children, but he thought that interest could be compelling nevertheless. So he wanted to interpret the statute more narrowly, limited to crush videos and dogfighting videos and the like. So he wanted, that's the constitutional issue that the majority didn't have to address. Okay? So the question after Stevens is, I've set this up for you, what is the constitutionality, what about the constitutionality of a statute prohibiting depictions of crush videos or extreme animal cruelty? Again, forgive me for restating the obvious, we're not talking about the acts themselves. We're talking about depictions of those acts. The acts clearly can be punished. They're criminal conduct. We're talking about depictions of those acts, movies, and the like. Here is what H.R. 5566 says. It's called the Animal Crush Video Prohibition Act of 2010. Animal Crush Video Prohibition Act of 2010. And it attempts to tie crush videos into obscenity or to obscenity in sex. Get this now. In the judgment of Congress, many animal crush videos are obscene in the sense that the depictions taken as a whole appeal to the prurient interest in sex, are patently offensive, and lack serious literary, artistic, political, and scientific value. Clearly an attempt to connect obscenity and sex to crush videos. The statute itself is limited to intentional acts of extreme animal cruelty. Crush videos, as you can infer from the title, are the major target, and Congress also said it's very difficult to enforce criminal sanctions, criminal legislation directed against animal cruelty itself against people. It's often done clandestinely and the like. So you see that Congress is trying to lay a foundation for what it's doing here. And the most important point that I've hinted at a moment ago, animal crush videos depicting such conduct are obscene. So the concern is to prohibit the creation and distribution of these crush videos. Are there some exceptions in the federal statute or the bill for veterinary purposes, for slaughter of animals, for food, and for hunting, trapping, and fishing? That's the statute that is proposed. And let me just, as I finish, where are we now in terms of time?
5 to 1.
5 to 1. Okay. As we finish, open up to any questions or discussion that you would like to have. Consider the following. First, that obscenity regulation and even child pornography deal with sexual conduct. Even the Ferber case, which deals with child pornography, defines sexual performance as follows: the actual or simulated sexual intercourse, deviant sexual intercourse, sexual bestiality, masturbation, sadomasochistic abuse, or lewd exhibition of genitals. That's child sexual behavior. There's nothing like that in terms of sexual behavior in the statute. To put it more generally, thinking back to what I said about obscenity before, these crush videos do not depict sexual conduct. And that's required for obscenity regulation and seems to be required as well for child pornography regulation. Next, consider that if the state or government argues that the interest in preventing cruelty to animals is compelling, just as we say the same for children engaged in sexual conduct, we permit cruelty to animals in many circumstances, including hunting and slaughter of animals for food. But we never allow child sexual abuse, which means that the level or the weight of the state's interest is considerably lower in children, in animals, than it is for children. And also, remember the justifications for creating a special unprotected category for child pornography included the facts that children have psychological harm and are affected by depictions alone. Long term, this stuff is there on the record, even when they become adults. Animals don't have psychological harm and are also, so far as we know, and are also not affected by depictions alone. So these are, in my view, meaningful ways of distinguishing child pornography from animal cruelty and crush videos. Now, you're not going to make the mistake that my students sometimes do, right? If I had said this to my students, they'd say, well, Professor, are you in favor of animal cruelty? Now, come on. We are talking only about constitutionality, and we're talking only about constitutional ways of getting at animal cruelty. And I don't think even this statute, however far it gets, is a constitutional way of doing it. Let me add one more thing. There is a famous case, also handed down or written, whose opinion was written by Justice Scalia. Let me put it to you this way. The case is the RAV case, but without going into detail in that. A statute that, even if limited to prohibiting depictions of crush videos or extreme animal cruelty, that is a video, that is communication that takes a position with respect to animal cruelty. It is viewpoint-based. And if it's viewpoint-based under the First Amendment, it is seriously questionable. So I have 3 or 4 reasons from a First Amendment perspective in saying that this particular proposed statute is unconstitutional. The question that the Supreme Court left open in the Stevens case, if and when it is ever resolved, will probably come out on the side of unconstitutionality as well. Again, we're not talking about the wisdom of this stuff. A lot that is constitutional is unwise, and a lot that is unconstitutional is wise. Laymen, non-lawyers, don't get it, but we do, and that's all I'm talking about, the constitutional constraints on it. And there you have it. Any questions or comments or observations?
I just had a question
Please.
/ observation. I've seen horrible videos of animals being horribly abused, but of course it was in furtherance of, protecting them and showing, look how horrible animals are treated. We need to do something about it.
Interesting.
So I'm just thinking, is that what you mean by viewpoint? Because they're advocating on behalf of animals by showing how horrible.
That's a very good question. It's not quite.
Stuff you're looking at.
The question is, what did I mean by viewpoint-based? I'll be very straightforward about it. By viewpoint-based, I mean, in this particular situation, the view being expressed by this kind of statute, this hypothetical statute, the bill, is against cruelty to animals. That's the viewpoint. And government, under a marketplace of ideas rationale or under a self-government rationale, is not supposed to be in the business of saying this speech is okay, this other speech is not, because we don't like the viewpoint expressed. Because who knows, there may be people out there who think that animal cruelty is a good thing, and depictions, therefore, are good things. The RAV case involved racism. And the Supreme Court said you can't just have a politically correct statute prohibiting certain kinds of speech that you like, but not other kinds of speech, but that you don't like, but other kinds of speech allowing it if you do like it. Viewpoint-based discrimination is the worst under the First Amendment. Does that answer your question? Yes, sir.
Since it's pretty obvious it's very difficult to open up a new sphere of unprotected speech, why do you think Roberts left the door open and Alito tried to keep it so that it was very specific, and he thought that it could be constitutional?
Well, there are probably a couple of answers to that one. The first is that as a general matter, although some of you may snicker when I say this, as a general matter, the Supreme Court is supposed to avoid deciding constitutional questions unless it is required to do so. And the snickering may come from a case like Citizens United, where the court reached out to decide a constitutional issue that it didn't have to. And secondly, Alito was arguing for the proposition that the court should have reached the constitutional question. He was arguing against the court's approach to the statute as substantially overbroad. Now, pretty clearly, you know how these things work in the Supreme Court. The justices sit down after the oral argument on a Friday or a Saturday, and they take a vote. And you probably also know that take a vote in order of reverse seniority. The youngest goes first. And youngest doesn't mean age, it means appointment. So that would have been, although that would have been Sotomayor at that point. And they take a vote. And they go all the way up. And the rule is, when the chief is in the majority, the chief assigns the opinion. When the chief is in the dissent, the senior justice assigns the majority opinion, and that's why so many opinions in 5-4 cases have been written in the past by Stevens. Right? He was the senior justice. So, Justice Roberts assigned this to himself. He wanted to make several points, and again, he might, Justice Alito is, I'm engaging a little psychology here, Justice Alito and Justice Roberts almost invariably vote together. So he was probably doing this to provide some sort of lengthier explanation, prodded by Justice Alito. That's my guess. Whether it satisfies you, I don't know. Go ahead, follow up, please.
Based on what you discussed here, it doesn't seem there will ever be a legal or legislative attempt that will in fact be constitutional to outlaw this kind of thing.
I think it is, to understate it, an uphill battle to, under the First Amendment, to criminalize depictions, descriptions of this sort. I do think so. Keep in mind, the sole justification for doing it is that it helps to enforce the prohibition against the conduct. That's what this is all about. Remember as well, that was the rationale in the Ferber case. It's not sufficient to criminalize child sexual abuse. We've got to go after the distribution network which makes a profit out of depictions. And that's the argument. I don't blame advocates of trying to use this. I don't know if it's going to be successful. Would I have a different sense of it if it had been 5-4 or 6-3? Maybe. And this is not a new issue in the sense that it's not limited to crush videos or animal cruelty. because there was a case, McKinnon, some years ago here in the Seventh Circuit dealing with an attempt by the state to prohibit the distribution of violent videos to children. You may remember that. And Judge Posner, I almost said justice, Judge Posner, pardon me?
God forbid.
I'm leaving God out of it. Judge Posner for the court said that violence is an important part of growing up. It's not like sex. It's not variable obscenity for minors, and violence can be closely connected to sex as well, can't it? And yet, God knows, we don't prohibit. We can't prohibit constitutionally depictions of violence, even if we say they're connected to sex. The sex has got to be obscene. Violence, even if some of us might think is obscene, is not in the technical sense obscene, right? It doesn't involve sexual conduct as such. And there is I think, cert granted, the court case will be heard this term. Interesting to speculate why. I think there's a video case before the court this term dealing with the First Amendment aspects of that. So you have to be very careful from a free speech perspective in going after speech as a means of getting after the conduct. We're much more comfortable in a society such as ours with government going after the conduct and leaving the speech alone. I like your point about the videos. Keep in mind that these vicious videos can actually be used to educate, which is the point that you were making. They can be used, if we get our hands on something, you see this stuff, you get disgusted by it. You say, we've got to do something about it. What was the movie that pretty much turned me off of most processed meat? Was it Food Incorporated? I'm not a principled vegetarian. I generally steer clear of meat for health reasons. But when I saw that movie, I thought to that documentary, I thought to myself, if this is how most of our meat products are produced, with all the gunk they inject into the animals that is thereafter going into us, leaving aside the animal cruelty, which is nasty, I said, I'm just going to minimize that. So I'm agreeing with what you said earlier. These vicious videos can be used to educate and not just to stimulate. So, that generated some questions. Well, that's good. Well, we'll go in order.
So, what you're saying essentially is that we need an Upson Sinclair. We need somebody who's going to write about, get the public's attention about how awful this is, what a bad effect it has, all of that, muckraking, in other words. Because when you talked about me, that's what brought me to Upton Sinclair. We need that kind.
You might want to tell some of these younger folks who Upton Sinclair is and what he wrote. This is a really educated group. Upton Sinclair, The Jungle, early part of the 20th century.
Which is about the stockyards in Chicago.
Right, very good. Okay.
And it is,
it's a classic.
It's a classic. You would never want to sausage. Go by the South Branches of Chicago River again. And that it sounds to me like that's what you're saying, because there is obviously, according to newspapers, the necessity is to increase the pressure of the public on law enforcement, on the legislature, and eventually on the court, to see these as extremely damaging. And not necessarily, the other side of it is, this is not necessarily something which is just damaging to the animal. Cass Sunstein's ideas about how this leads to cruelty to people.
I don't disagree with that assessment.
Yeah.
I think that's correct. Mm-hmm. I can't understand how people can be so vicious to animals. I cringe whenever I see something like that. So I'm with you. In a sense, the Stevens litigation helped to educate the public, didn't it, about this? I mean, litigation that gets to the Supreme Court especially has an educational component to it. The justices get educated, the entire public gets educated about it as well, and that's all to the good. So nice point. Yes, sir.
Well, sort of hybrid these things and have, crush videos relative to children as opposed to animals, and, how that would fit into the scheme.
How do you mean?
Well,
Give me a hypo, as we like to say in law school.
physical abuse of children as opposed to physical abuse of animals. And that might come closer to the obscenity, child or child pornography, than to animal cruelty.
Well, you're raising, I'm not sure it does, by the way, as nasty as the hypothetical is. There was talk, I don't know if anybody ever saw any, some years ago, talk about snuff videos. You remember that? Now, from a constitutional perspective, I'll describe what that is, and from a constitutional perspective, it's actually easy to deal with. Those were videos that were made of somebody being killed, supposedly. Now, the reason that, and then what happens, can government prohibit the circulation, the dissemination, and communication of the so-called snuff video? Seems to me that's a relatively easy case, at least early on in the chain of distribution, because the person is actually participating and enabling, so you've got an accessory there. The issue that arises in all of these cases is not when, suppose you have somebody setting up a crush video. The person who literally photographs takes the video. It seems to me that person can be prosecuted as an accessory in connection with the conduct itself. It's somebody down the road that we're talking about in connection with free speech. The video is made, and then it's sent on down and sold, hundreds of miles away. And the question is, does the person who sells it hundreds of miles away, who had nothing to do with the making of the video, just the selling of the video, can that person be prosecuted? And the short answer is, constitutionally, no, under the free speech clause. See, so there's an end run when somebody's actually videotaping it as it is ongoing. The end run is accessory. You've got somebody who's engaged in the conduct, enabling the conduct.
Well, then I'm sorry.
No, go ahead. We're going to go in order, and then we'll get back. Go ahead.
So, based on everything you've said so far, and the likelihood that any of this would never be constitutional, shouldn't animal rights groups keep pushing their legislators to keep coming up with laws that try to make it constitutional, so that whoever is performing the conduct has to have the burden of the cost of the government coming after them and then going to the legislature?
Be careful what you wish for. What you're wishing for, here's what you're saying, taking your argument to an extreme. We know that what we're trying to get at is very nasty. We're going to enact legislation that is pretty clearly constitutional and make them fight about it. We don't want prosecutors doing that, do we? To any of us. And besides, I'll tell you what can happen. I know from the Section 1983 civil rights work that I do, you can sometimes bring a lawsuit seeking declaratory and injunctive relief, not just as a defense in a criminal case, and you win, and you know what you get if you win? Attorney's fees. This is not costless. The costs are not imposed only on the individual who's being gone after. So I'm not sure I want to go that route. I don't think you would either. To come up with something blatantly unconstitutional, but just stick it to them. See what they do. You had a point, then you had
I think I have a problem if what you're saying is that a person is protected if in fact they're distributing snuff films or films depicting human beings being tortured and mutilated. So that's protected, but then you have a group of people who want to protect animals who are also being killed and mutilated, for the depiction of animals.
Right.
I have a problem. I think that human beings should be, who are being depicted being murdered and mutilated, should also, that depiction, and that should not be protected speech, even before any kind of protection of animals. I mean, that's just my view. It doesn't make sense to me. You see what I'm saying?
Well, can I ask you a law school question, which takes us beyond?
You were my constitutional law.
When did you get out of here?
81.
81. Way back in the last millennium. My
Exactly.
goodness.
Absolutely. Long time ago.
Okay. Let me give you a question back, and then you had this is taking us a little bit away from animal rights, but your question is going to bring us back, right?
Yeah.
Just very simply, suppose somebody who works for the government discovers that the government has engaged in criminal behavior involving foreign affairs, and that person starts photocopying all the documents and then releases the documents to the New York Times and the Washington Post, depending on papers. Now, can the New York Times and the Washington Post be prosecuted constitutionally? Well, I have a real problem with that one, because they themselves did not participate in the illegal activity of photocopying classified information. Pardon me?
That was a prior restraint.
Very good. You're good. That was a prior restraint case, but I think the result would have been the same even had it not been a prior restraint. You're absolutely right. It adds a certain twist to it. So I told you we're getting a little far afield, but I think, here's my general point, I think we've got to be very careful before we go after speech as a way of getting at conduct, as a general matter in a society which values free speech.
Okay, I'm just saying that, if my understanding is that the case that was just struck, that you're speaking of, the
Stevens
case, in that case, I believe the litigants, the petitioners, the plaintiffs, wanted the depiction of cruelty of animals to be found is not protected.
Yeah, these were they disseminating dogfighting videos. Exactly. That was the Stevens case.
Precisely. So I'm just saying that I just find it odd that the dissemination of human beings being slaughtered.
We don't have any case like that.
I think part of the issue was, especially with one of the reasons the statute was written and it was aimed at prohibiting crush videos, is because, as was said in I believe H.R. 5566 in the legislative intent, is because it is so difficult to go after the conduct, because it's often whereas I mean I don't again we're speaking about a hypothetical video of someone being killed, I don't know, but with crush videos it's very difficult to find out who is doing the action, who's doing the crushing, who's doing the videotaping. It's very hard to go after the conduct, and hence the statute to prohibit the depiction of the conduct.
Yeah. Good. Yes, sir.
I guess practicing this as the youngest person here, not doing particularly well in constitutional law.
How do you know? You're still in the course, aren't you?
No, it's okay.
Oh, you finished your third year. Is that what you said? Okay. We'll give you credit for this.
How about attacking it from a different front? My understanding is that the ultimate end goal for the animal rights group is to eliminate animal abuse, and my opinion is that it's probably most easily correctable to younger people to grow up in a household without animal abuse. What about regulating it so you make it like pornography, where you can't distribute it to minors? Could Congress feasibly pass something where, since it, listening to you, it doesn't seem like outright banning it or criminalizing it is going to pass constitutional muster, but how about getting a small victory by prohibiting the distribution?
Well, that's very interesting. You're suggesting an analogy to something called variable obscenity. I told you what the obscenity standard was for us as adults. There is a Supreme Court decision which talks about variable obscenity in connection with minors. And it is that we ask the same questions about appeal to prurient interest, patent offensiveness, serious value as related to or as applied to minors. That's why it's called variable obscenity. It wouldn't be obscene to us, but it's obscene for minors. I think we'd still have the same problem.
Okay.
I think we still have the same problem since we are still focusing on depictions of sexual conduct, and we don't have those in this connection. With your it's very clever, and it also reminds me of this the violent video games kind of things. There is an overriding principle, by the way, that is implicated whenever government tries to keep things away from minors, and it happened with the internet as well, various attempts to keep obscenity, pornography away from minors. We don't want all of us adults to be dumbed down to the level of minors. We don't want that standard to be applied to us. So there have to be ways of dealing with this problem more directly, but you have to be very sensitive to what happens when you try to do this through regulation of speech. We're all in danger of being dumbed down. And this is a principle that was set out by the court 50, 60, 70 years ago in cases involving obscenity and the like. We're not doing it for adults, we're doing it to protect minors.
So you're saying that the obscenity analysis doesn't work because there's no actual sexual conduct?
That's what I'm saying in part. I also mentioned the compelling governmental interest issue in connection with crush videos, very different for children in comparison to animals.
But, I understand why the child pornography comparison and applying Ferber failed, but I don't understand. I guess I don't understand why obscenity wouldn't work.
Where is the sexual act?
Well, I thought it only needs to, like you said earlier, be a turn on and not to everyone watching, but to some.
Well, I hope I didn't give that impression. Appeal to prurient interest kicks in once you have a depiction or description of sexual conduct. Look, there are people who are fetishists, who can be turned on by lots of things sexually. And I mentioned violence before, right? And I'm not even sure. I'm so far from being a fetishist. I think that I can't even think of a good example.
Do you think?
Shoes. Okay, that's good.
It's perfectly legal.
Do you think that the category of obscenity would be expanded at some point to cover violence?
No.
Extreme violence?
No. Obscenity is not going to be expanded to cover violence as such. We only need to point to history and tradition to say that we're not going to do that. It's amazing that the Ferber case with child pornography got basically unanimous decision. I told you there was a little quibbling about the scope of the decision, but what justice is going to come out or seem to come out in favor of child pornography?
Do you think Ferber will be overruled?
You
think Ferber will be overruled?
No, how? In what regard? No. Oh, you mean the Stevens portend that? No. Ferber is good law, and it was totally uncontroversial, and it seems to have worked pretty well. I've seen no indications that people are mounting test cases to challenge prohibition on distribution of child pornography. I have not seen that. Please.
If you were asked to draft a constitutional statute, what might you look at or think about?
Well, I've suggested that I can't really come up with one with regard to depictions and descriptions of animal cruelty. I just can't come up with one that is constitutional. Pretty clearly, Alito thinks that is constitutional, and he tied it in his dissent to its intimate connection to the distribution to the animal cruelty itself. I can't come up with one. I don't think this is it. Does anybody know what the status of this thing is? It's before the Senate.
It was amended in the Senate.
Right.
And then it had to go, I believe, back to the House.
The Senate has nothing else to do. I'm sure it'll get to this tomorrow. No, but seriously, I don't know what the status is. What committee does this go to? Does anybody know?
Probably.
Pardon? I mean, I don't know what committee or subcommittee this would go to in the Senate. Judiciary Committee? I don't know. Anything else? Well, thank you. This was fun. I enjoyed the questions and
Thank you.
answers.